Okay, I see we're live. So I would like to greet and welcome everyone participating in this webinar organized by the Alternative Dispute Resolution Clinic of the Master of Laws program at American University of Armenia. The webinar is dedicated to a very important topic considering our current circumstances, especially post-war. So I'm very much thankful to our two presenters today, very remarkable presenters that will be talking about issues related to protection of investment, international investment, especially in the circumstances of armed conflict post-war or during war. So without further ado, and for the sake of saving more time for the Q&A session, I will give the floor to Mr. Alexander Yanos, who is a co-chair of International Arbitration and Dispute Resolution Team and a partner at Alston Bird LLP. His arbitration practice includes commercial, financial, and treaty-based disputes, particularly in the energy and mining sectors in Latin America. He obtained a finding of unlawful expropriation in one of the largest investment treaty cases ever filed before the International Center for Settlement of Investment Disputes, ICSID, in arbitration against Venezuela. In another decision against the sovereign state, the US Supreme Court reinstated an award of a British multinational oil and gas company client against Argentina. So needless to mention that Mr. Yanos has been presenting clients before many international arbitrational tribunals, including ICSID, ICC, LCIA, AAA, SCC, etc., ICJ. So without further ado, please, Mr. Yanos, start the presentation. And just to inform, our second presenter is Mr. Egishe Dzhazoyan, who is also a very experienced arbitration specialist. As a partner at King & Spalding, he represents clients and appears as counsel in both commercial and investment treaty arbitration matters before leading European tribunals, including, again, LCIA, ICC, UN Commercial International Trade Law, and of course, Stockholm Chamber of Commerce, as well as the International Commercial Arbitration Court in Russia. Dzhazoyan also frequently advises clients in court proceedings and has particular experience in matters involving enforcement of arbitral awards against sovereign states, as well as complex offshore commercial fraud and asset recovery disputes. So I'll give the structure. So the first presenter, Mr. Alexander Yanos, is going to speak about investor-state arbitrations resulting. His particular presentation will be dedicated to protection of investments with relation to Crimea, specifically post-Crimea conflict. After Mr. Dzhazoyan will speak mostly about draft articles on the effects of armed conflicts on treaties and the Vienna Convention on the law of treaties. And after we conclude the presentations, we will have a session of questions and answers. I'm looking forward towards receiving your questions. You can send those in chat. I assume our format will allow that, or you may also speak up. I understand our administrator who is helping us today during the webinar, Mr. Aram Aghababyan, the coordinator of the clinic, will be helping us with regards to the specific technical issues because I'm not so much sophisticated at those. So thank you for your patience and for this long introduction. I'm passing the floor to you, Mr. Yanos, please start.
Okay, thank you so much. First, I want to thank the conference organizers and especially Aram Aghababyan for putting this together. And thank you also Adelita for that kind introduction. As she said, I'm going to speak briefly about the subject of investment treaty protection and what investors in the Nagorno Karabakh slash Artsakh region can learn from the experiences with that investors in the Crimea had after its annexation by Russia recently. And so we'll begin with just a refresher on what happened in the Crimea. Then we'll talk about investment treaty protection and how it could relate to what happened in Crimea. And we'll talk about how tribunals addressed the key issues, the key legal issues that arose in relation to the claims brought against Russia arising out of the annexation of Crimea, and how Russia responded. And then we'll try to think about how all of that relates to Artsakh slash Nagorno Karabakh and what sort of claims might be available now. So first, just to remember that, and we just have the timeline, I'm not going to repeat it, but essentially there was this period where obviously the Crimea was Ukrainian, and then there were some noise from the Russian government about taking over Crimea. There was the arrival of the Green Men, which were maybe Russian, maybe not. And then those were the masked Russian troops. And then, of course, there was the formal annexation of Crimea by the Russian government, which was never recognized by the international community. And that's very important. The international community considered the annexation of Crimea to be unlawful and doesn't recognize it. But nevertheless, of course, Russia is the de facto controller on the ground, and that is what mattered for investors in Crimea. So in the aftermath of the annexation, there was property that had belonged to foreign nationals, some of them Ukrainian, some of them from other countries, that was either taken by Russia or after the annexation, or destroyed by the Green Men or other forces. And these owners faced a problem. Ukraine was the internationally recognized ruler of Crimea, but obviously they were not the de facto rulers of Crimea. And so who would they turn to for compensation for the loss of this valuable property? And to give you an idea, there were banks, there were petrol stations, there were real property that was destroyed, all sorts of property, and the question was, how do they obtain compensation for this loss? And the answer, in some cases, where the investors were either citizens of the Ukraine, which had a bilateral investment treaty with Russia, or citizens of other countries that had treaties with Russia, was to bring a bilateral investment treaty arbitration against Russia seeking compensation. So what is an investment treaty arbitration? Well, that's basically there in the first investment treaty was in the 50s, but most of the treaties were creatures of the 80s and 90s. There was a proliferation of these agreements between two countries in which each country made a reciprocal promise to treat the investors of the other country in accordance with international law, and we'll talk about what that means. But they also included these reciprocal promises to arbitrate disputes. So essentially, in this case, Russia said to Ukrainian investors, we will treat Ukrainian investors fairly and equitably. We won't take their property without compensation. And if they feel like they were mistreated, they can bring an arbitration. And Ukraine made the same promises to Russia and Russian investors. So what do these treaties promise? As I said, the most fundamental promise, other than the arbitration promise, is no expropriation without fair, prompt, and adequate compensation. They also promise fair and equitable treatment, although that's less of an issue here. But for the purposes of the Crimean investors, expropriation was important. Full protection and security is important. And we'll talk about what that means. And then there's also a provision which could be relevant here, that compensation for damages incurred as a result of war or armed conflict must be given that is no less favorable than the compensation accorded domestic investors. What does that mean? So let's say property was destroyed in the Crimea during the armed conflict, and Russian investors, Russian owners who had property that was destroyed were paid for the property that was destroyed. Ukrainian investors had to get the same deal. Okay, and so thinking, I'm jumping ahead, but think about what that means in, Artsakh, in Nagorno Karabakh. If there was a property, let's say you're a Dutch investor and you had property in the region that was destroyed, but other property in the region that was destroyed during the conflict, the Azeris provided compensation. You should be entitled to the same compensation. So that, just keep that in mind as we move forward. But turning to the subject of, I use that phrase, what is full protection and security? Well, it can mean different things in different contexts, but it was very interesting to think on a case, AAPL against Sri Lanka, which is actually one of the first investment treaty cases ever. The claimant had a shrimp farm that was overrun by rebels during the Civil War. The tribunal said there's no strict liability for such damages, meaning just the fact that your property was destroyed during the Civil War doesn't entitle you to compensation under the full protection and security guarantee, but it does oblige the state to exercise restraint on its own part in the use of armed forces to protect foreign investors. And it also involves the obligation to protect investments against rebel forces or other forms of private violence. So there are situations if the foreign state doesn't exercise due diligence to protect you as a foreign investor, you could potentially argue that that is not full protection and security. Okay, so in the Crimea, in the aftermath of the annexation, 13 cases were brought. Most of them were brought by Ukrainian investors. So they had the interesting situation where before the annexation, it was a Ukrainian investment in Ukraine, but 1 minute after the annexation, they became Ukrainian investors in Russia. And so they argued that they were entitled to protection under the treaty because at that moment, 1 minute after the annexation, they became, not by their own choice, Ukrainian investors in Russia. But there were also investments under different treaties. So obviously, the first question that the tribunals had to answer was, if you made an investment in Russia, if you made an investment in the Crimea as a Ukrainian in the Ukraine, but all of a sudden you found yourself in Russia after the annexation, do you qualify for protection under the treaties? And the tribunals said yes. And I listed a few of these cases here, but they said that just because you started out as a Ukrainian investing in the Ukraine doesn't mean you're not entitled to protection if the territory in which you invested suddenly becomes foreign. So that's obviously very important. thinking ahead to Nagorno Karabakh, to Artsakh. Second, could investors seek compensation from Russia without recognizing Russia's sovereignty over Crimea? This was especially important for the Ukrainians trying to sue Russia, right? They wanted compensation from Russia, but they did not want to accept Russia's annexation of Crimea as lawful in their pleadings. And so the question was, did you need to accept the Russian annexation to make a claim, or could you do so without making that recognition? And the answer again was you did not need to recognize Russia's legal right to control of the Crimea. You merely had to recognize Russia's de facto sovereignty over Crimea and its own claim of sovereignty. And that was very important, again, especially for the Crimeans, for the Ukrainians suing Russia. And of course, that'll be important when we look ahead to Artsakh, to Nagorno Karabakh. And then the third, question was, could the investors seek compensation from Russia for property that was destroyed as opposed to taken? And here again, we're looking at it depended on the treaty, but where the treaties had the provision that I put up in the screen in the Russia-Ukrainian treaty that deals with it was similar to the damage provision I read to you earlier. This idea that you have, if Russia is compensating Russians who incurred damages during the Crimean takeover, they had to provide Ukrainians the same deal that was available. How did Russia respond to these treaty cases? Well, initially, they adopted what we call the empty chair approach. They rejected the right of claimants to bring claims under these treaties and didn't show up. They didn't appoint an arbitrator. They didn't argue the cases in front of the arbitrators. They ignored them. However, after a series of losses, not surprisingly, Russia changed its tune. So in May of 2019, all of a sudden, Russia showed up and started challenging these awards in court, saying it was unfair and that the awards were improperly made. So now let's think about Artsakh, about Nagorno Karabakh. So can we see a situation in which similar claims could be brought? Well, clearly, there are going to be investments in the region, and those investments arguably were not made in Azeri territory when they were made, but they are now, as a result of the settlement between the Armenian and Azeri governments, arguably in Azeri territory, and that's certainly the position of the Azeri government. So if you are suddenly with property that the Azeris claim is within their control, the next question is, of course, are there any treaties? And we'll talk about that in a moment. And that the answer is, of course, it depends on your nationality. There's no bilateral investment treaty between Armenia and Azerbaijan, although if it's an energy investment in Artsakh, in Nagorno Karabakh, there is a chance to bring a claim as an Armenian against the Azeri government under the Energy Charter Treaty. But other nationals or corporations, like you could be an Armenian with an investment in the region through a Dutch vehicle or one of the other countries that have a Georgian vehicle that have treaties with the Azeri government, and there would be an option there. And so the argument would be whether you recognize the right of the Azeri government to control the territory in which you made your investment or not. Azerbaijan asserts its sovereignty over that territory and therefore assumes the obligations vis-a-vis investors under the treaties it's signed. And again, we remember, a key question would be, well, when you started out and you made your investment, you didn't consider yourself to be investing in Azerbaijan. Does that matter? No, it doesn't, at least under the analysis as applied by Everest and some of the other tribunals that dealt with these Crimean cases. They said, well, whether you started out believing that you were investing in Azerbaijan is not important. The point is, at a certain point in time, you found yourself with property that the Azeri government exercised dominion over, right? And that's what's happened here in the Artsakh, Nagorno Karabakh territories. You don't have to recognize Azerbaijan's right to exercise that dominion, but you can recognize that they certainly claim that dominion, and you are suffering damages as a result of that dominion. So, as I mentioned, the Azeri government has signed a number of treaties, 44 in particular, and those treaties cover a lot of countries that are part of what we all think of as the Armenian diaspora. So there may be, and I'll give you some examples in a moment, but I do want to mention again the ECT, the Energy Charter Treaty, because if let's say you have a petrol station and that petrol station was destroyed or taken, or if you had a wind farm or a dam, a hydroelectric dam, or I don't think there were any oil wells, but if you did, all of those things, or a gas well, all of those things would qualify as energy investments in Nagorno Karabakh, in Artsakh, and that are suddenly energy investments in Azerbaijan, and therefore subject to protection under the ECT. So an Armenian who owned a hydroelectric dam in Artsakh that was taken by the Azeris would have a claim for expropriation against Azerbaijan under the ECT. But as I said, if it's not an energy investment, the Armenian citizen wouldn't have a claim, but Armenian corporations, or rather corporations owned by Armenians that were actually incorporated in other countries, whether it's Russia or Syria or Benelux, Jordan, Switzerland, Greece, Austria, the United States, all of these countries, the UK, have treaties with Azerbaijan. So a UK company that had property in Artsakh, in Nagorno Karabakh, that was taken by the Azeri government would be able to bring a claim against the Azeri government for compensation for that taking. Or if the Azeri forces destroyed the property during the conflict and didn't provide compensation to the UK company, but did provide compensation to Azeri companies or Azeri property owners that suffered damage, that could be a claim. Okay? So I'm at my 20 minutes, and I do want to make sure we have time for questions and answers, but I want to thank you again. It's a pleasure to be a part of this panel, and it's an honor to be sharing the stage with my esteemed colleague, Mr. Dzhazoyan, and I'm looking forward to hearing his comments. Thank you so much.
Thank you very much, Mr. Yanos. Very interesting presentation. I'm sure it has generated a number of questions, and I've seen people already posting in the chat session. I have my own questions, so I might abuse my privilege as moderator and start off. But before we do this, let's also pass the floor to Mr. Dzhazoyan for his part of the presentation, and he will speak about the draft articles on the effect of armed conflicts on the treaties. So without further ado, please, Mr. Dzhazoyan, looking forward to hearing your presentation. Thank you, Mr. Yanos.
Thank you, Adelaide. And obviously, I would like to start off by saying thanks to Adelaide, to Aram, and to Mr. Yanos for his very interesting presentation, which does indeed overlap with mine. So the topic of my presentation, as you know, is about war and peace in international investment law. And this is not so much an homage to Leo Tolstoy's famous novel, but also a pretty important, and I would say ever more interesting and ever more pertinent issue, which will, in my opinion, increasingly now arise in international context. And Mr. Yanos was describing one of the most interesting and notable recent examples of the events and disputes relating to the Crimea question. But of course, the story goes back. So some, for example, academics dated back to the 2011 events of the Arab Spring uprising in North Africa and the Middle East. Crimea came 3 years later, and unfortunately, I have to say, it looks like it was Armenia's turn last year with the recent hostilities in the Artsakh area in Nagorno Karabakh, which we'll, of course, we're very familiar with. So in terms of the way I want to structure my presentation, and I have to apologize, I do not have any slides, but I'll try to make it as structured and as easy to follow as I can. So I think it's fair to start by saying that in essence, in this context, we're dealing with various parts and instruments of international law, be it international investment law, human rights law, or international humanitarian law, or law of armed conflicts. But I think in terms of the key legal instruments, which we find at the intersection of all these various branches of international law, those three are the ILC draft articles on the effects of armed conflicts on treaties. So that's number one, and I'll come back to that instrument in a minute. Then we obviously cannot escape the elephant in the room, the Vienna Convention on the law of treaties, which always comes up in this type of discussion. And that's the second instrument. And the third instrument, which I think is relevant in this context, and which I'm going to talk about a bit later, is are the draft articles on state responsibility, which represent customary international law and contain also a few pertinent provisions with respect to this topic. So, and then before we move on to a more granular level, I think, as you probably judged by the title of my lecture, this whole war and peace discussion, I think it's an apt title in as much as it summarizes or outlines the two competing policies which one can find in this context. Policy number one would be the maximum freedom for the state in certain situations, in this case, pretty grave and important and rare, or at least in theory, rare situations of armed conflict, when the state is entitled or wants to take certain measures to protect its interest. So that's the first policy. On the other hand, of course, you have the also very important policy, which is the promotion and protection of investment and trade and commerce, and an effective protection of investment, of course, which flows from that. So how would we then reconcile these two competing policies? Where is the balance to be struck? It's a very tricky question, and I'll try to give answers to the best of my ability, but sort of a little spoiler, if I may, at this stage, there is no definite answer in that a lot, of course, depends on the facts of a given case, and situations do vary quite considerably from a case to another case. But let's start with the ILC our draft articles on the effects of armed conflicts, which I mentioned at the beginning. They were adopted in 2011. And the departure point here will be Article 3 of those draft articles. And that article essentially stipulates that the existence of an armed conflict does not ipso facto, i.e. on its own, terminate or suspend the operation of treaties. So in other words, this article Article 3 lays down what we can call a principle of a continued application of bilateral investment treaties and investment protection, which is of course very important. Be it as it may, it's also quite general in the sense that it doesn't really say much beyond that, because it's fine that there's continuity, but surely as every law student knows, every rule has exceptions. So let's try now unpack this article and this principle and see whether there is anything there which will sort of make the analysis more nuanced. And I think the first thing we should look at here in this context is Article 6 of the same draft articles. And that article talks about factors indicating whether a treaty is susceptible to termination, withdrawal, or suspension. And effectively, it does lay down a general framework which would enable to conduct an analysis and figure out whether a given treaty may be susceptible to termination because there is an event of armed conflict. So not just generally termination, but we're talking again specifically here, the context is quite particular, which is an armed conflict. And the two key contexts here, which are provided for by this Article 6, are the nature of the treaty, in particular its subject matter, object, and purpose. And the second one is characteristic of the armed conflict, such as its territorial extent, its scale, intensity, duration, and so on. So again, we see, as I started off with saying, that there is this principle of continuity, which you will see in Article 3. But generally, that doesn't mean that every treaty will necessarily survive an armed conflict. And of course, a very important caveat should be added that these are general rules, and to the extent that specific treaties provide specific mechanism rules, particular rules with respect to particular types of armed conflicts, then as a matter of general principle, those specific and particular exceptions or situations should apply and should therefore trump the general rule. So, and then remember, as I said at the beginning of the lecture, we also have the Vienna Convention, which I want to talk about briefly. You will appreciate, of course, that all of these topics are quite complex, and it's quite difficult to try to compress them within a 25-minute presentation. So, but I think the Vienna Convention we should talk about briefly, as I said, and the starting point here, it will be Article 73. And effectively, this is a savings clause, as we call it. And Article 73 states that the convention, the Vienna Convention that is, does not prejudge any question that may arise from the outbreak of hostilities between states. So it appears then that the Vienna Convention gives one a carte blanche, one would think, in this context. Well, not quite, because the convention itself, the treaty itself, the convention itself also obviously contains two very important relevant paragraphs or articles, which may be also potentially relevant in this type of discussions. And those are Articles 61 and 62. We don't have to go through those articles line by line. Suffice it to say that Article 61 deals with the situations of supervening impossibility of performance. And Article 62 talks about fundamental change of circumstances. So I guess this is relevant in as much as one could ask, how can the states try to effectively escape any liability under a given treaty by deploying potentially the Vienna Convention as a tool in order to do so? And as I just outlined, the convention itself gives at least two such mechanisms, being again the Article 61 and 62, supervening impossibility and fundamental change of circumstances. But at the same time, it's important to note that these articles, both of them, set quite a high threshold in terms of actually making sure that it's not that easy to successfully invoke these articles, and hence I think it would be fair to say that albeit states try to invoke those articles from time to time as basically as a defense or as a plea with respect to various claims brought by various investors, in most cases those articles, the invocation of those articles, as I said, is quite difficult to succeed because the standard the threshold is quite high. So, and hence one could conclude that this juncture, that the pendulum, remember we talked about the competing balances or the competing policies, war or peace. So hence I think it will be fair to summarize that at this juncture, that the Vienna Convention hardly provides the states the protection which would then enable someone us to say that the policy one, i.e. state interest, trumps policy two, i.e. investor interest. So, but let's now move on to a bit more granular level and look at what type of specific substantive provisions would various BITs and bilateral investment treaties and multilateral treaties ordinarily contain, which actually do arise in this specific context, i.e. when an investor brings a claim which is somehow related to an armed conflict or certain military hostilities. And if you recall, Mr. Yanos in his very interesting lecture talked about the full protection and security type of clauses, which we see in lots of treaties. So this is a quite a well-known concept. It's also quite uncontroversial, although there are some discussions about the exact scope of this type of clauses. But I think it's effectively, and as you heard, it effectively involves a duty of the state to refrain and a duty to protect property of the investor. It also involves an obligation of due diligence. So in other words, it only exists to the extent of the reasonable use of the state's capabilities. And I think the importance of this is not to be underestimated in the sense that this type of clauses, i.e. clauses with respect to protection and security, they don't create absolute liability. And it's quite difficult, certainly in my practice, for investors to successfully invoke these type of clauses. That doesn't mean that investors don't resort to them. They do quite a lot. But at the same time, again, the threshold is quite high, and the states are quite these days adept at applying various defenses and exceptions to this rule. The other type of clauses we can look at here in terms of how we find them in particular BITs and multilateral clauses, treaties, are the non-discrimination clauses. And again, these are pretty familiar, I guess, to law students, because we're talking about here like things like national treatment and most favored nation treatment, and such as restitution, for example, compensation that the states may take with respect to war losses. So, for example, a prime example of this would be Article 12.1 of the Energy Charter Treaty, which Mr. Yanos talked about. That talks about war or other armed conflict, state or national emergency, civil disturbance, or other similar event. So these type of clauses, they are designed to operate in favor of investors, but at the same time, I have to say, it's fair to say, in my view, that they provide limited comfort because they do not create substantive rights to restitution or compensation. And in effect, they are contingent on successfully importing provisions from another treaty or from a similar treaty or or a situation to the situation at hand. So that's why their use to investors in this context is quite limited. Then you have what's called another type of clauses of similar nature, which are called extended war clauses. And an article of these are much more rare. An example of this would be probably, for example, Article 12.2 of the ECT. So these extended war clauses, they relate also to war or other armed conflict, emergency, revolution, insurrection, civil disturbance, and similar events. So, and I think the key difference between these type of clauses is that, and the ones I talked about, is that the compensation here is due only if the adverse act in question was caused by government forces and not by rebel forces. You'll recall when Mr. Yanos, I think, talked about full protection and security. I think there was that Indonesian case which talked about rebels. So I think, so there's a distinction here in the sense that these type of clauses do not cover rebel hostilities. But at the same time, they are quite useful to investors, or potentially useful in other respect, which is that unlike the non-discrimination clauses that I touched upon earlier, these type of clauses, they also grant substantive rights to investors. But I have to say that these type of clauses are quite, meaning extended war clauses, are quite rare in practice. And I mentioned the ECT. You also find them in some bilateral investment treaties concluded by the United Kingdom. But overall, they're quite far and few between, I have to say. So summing up at this juncture, what do we see? We see a number of typical clauses in various investment treaties, some of which are more prevalent, like full protection security. Some others are much less prevalent, like the extended war clause, the one I talked about just now. But as I said, the general idea of those clauses, or behind those type of clauses, is to give protection to investors. However limited that protection turns out to be in a particular case, which, as I explained, is unfortunately to investors is the case. But what about the states? What about clauses which would give protection to states? Those clauses are also can also be seen in some treaties, and they are called security clauses. And effectively, they could be described as a powerful shield which will enable a state to protect its interests with respect to any claims and any doctrines and any type of clauses which investors would invoke from time to time in disputes relating to arms conflicts. And these type of security clauses, which are designed to benefit states, can in turn be divided into two categories. The first one are the ones we see in some treaties, for example, US-Argentina bilateral investment treaty, which talks about measures necessary for the protection of the state's essential security interests. So these type of wording generally suggests that any measures taken by a state in this context will be ordinarily subject to the scrutiny of tribunals and hence be of more limited use or benefit to the state. But there are also so-called self-judging type of security clauses, which are designed to protect state interest. And these type of clauses means that the state takes the measures, which is reserves the right to take measures, basically has full discretion effectively in terms of what it can do. And again, of course, there has to be very clear and concise wording to that effect in a given bit. But this is probably the most potent protection and sort of the most sturdy shield that the state can afford to itself, these type of self-judging clauses. And an example of this would be certain recent bilateral investment treaties concluded by the United States of America, which refer to, and I'll just quote, "Nothing in this treaty shall be construed to preclude a party from applying measures that it considers necessary for the fulfillment of its obligation with respect to the maintenance or restoration of international peace or security, or the protection of its own essential security interests." So as you see, it's quite a curious this is quite a curious type of clause, because it talks about two things effectively here: restoration of international peace or security, number one, and number two is protection of its own essential security interests. So, and I think just pausing there, it's of course no coincidence that you'll find these type of clauses in US bids, i.e. in treaties concluded by the United States, because rightly or wrongly, and not prejudging any views on other panelists on this panel, but rightly or wrongly, certain commentators certainly view policies and of the government of the United States as akin to sort of walled policemen at the global geopolitical stage, trying to restore peace and order or law and order in various parts of this world. And leaving aside the geopolitical and moral and political angle of that very important question, which is very debatable, I have to say that at the same time, in reality, this is a very shrewd and clever mechanism and tool, in my view, which is deployed by the U.S. government, because to the effect that the U.S. government can effectively compel, for lack of a better word, to another party, another contracting party, i.e. another sovereign state, to enter into a treaty which will contain language to the effect that I just cited, well, then it just means that sort of gives the U.S. government a legal basis to do certain things which ordinarily will be deemed potentially, for example, illegal under international law. But again, that obviously then in turn depends on the fact also that the U.S. is not just an ordinary country. And of course, what the U.S. can bargain for its own benefit is very different to, unfortunately, what, for example, a country like Armenia can bargain for its own benefit when it comes to its own bilateral investment treaties. So summing up, these self-judging security clauses, which I just outlined, they give the state the most far-reaching latitude and freedom of action. And very briefly, coming to an end of my lecture, I just want to touch upon a couple of other examples of what kind of other shields, so to speak, can the state resort to in terms of defeating investment claims which are brought in the context of armed conflicts and military hostilities. And if you recall, when I talked about the Vienna Convention, I mentioned the impossibility of performance and the fundamental change of circumstances, which are the two articles which are embodied in the Vienna Convention itself. But what about customary international law? Can the state do something or invoke any defense under customary international law, which will not ordinarily be available to it, either by virtue of the Vienna Convention or by virtue of any type of security clauses, which I just talked about? And there are such concepts, there are such doctrines which the state can resort to, which one finds in customary international law. And those can be found primarily in the International Law Commission's article on state responsibility. Remember, these are at the beginning of this lecture, I was talking about the intersection of three various tools and instruments under international law. So these articles were the third one I mentioned. And very briefly, if you look at articles 23 and 25 of the ILC articles on state responsibility, Article 23 talks about force majeure and Article 25 talks about necessity. So again, these are other types of potential shields, so to speak, which the state can resort to trying to justify whatever action they have taken or not taken in the context of armed conflicts. But again, a bit like with the Vienna Convention, defenses of impossibility of performance or fundamental change of circumstances, which I have to say on a certain level are quite overlapping and similar to the doctrines which I just outlined. These type of defenses, force majeure, necessity, are quite difficult for the state to invoke. And for example, in terms of necessity, the doctrine application, the state must effectively, one way to prove on discharge's burden for the state will be to prove that it's effectively lost complete control over part of its territory as a consequence of armed conflict. Basically, nothing short of that will enable the state to successfully invoke the necessity type of defense. Although, again, cases are different, of course, but this is just an example of how difficult it is for a state to simply say, well, I don't want to pay, there's a war, and I invoke force majeure, for example, or I invoke necessity. It doesn't quite work like that. And obviously, the state must come up with the facts to make good on its case. So summing up this entire lecture, as I just outlined, or at least I've tried to, you have these two competing policies which are reflected in the title and name of the article, of the lecture. Again, the two policies, one protecting the state, the other one protecting the investor. And as I outlined or alluded to at the beginning of the article, I don't think it's fair to actually answer in any certain shape or form with respect to which policy trumps which. And I think it's fair to say in the end that a lot, as always, depends on the facts. And I think it's important to bear in mind in this case that individual treaty language is also extremely important, because sometimes some treaties, at least, they have certain clauses which are peculiar. And of course, they have to be taken into account in the context of a given dispute. And the facts are different and hostilities are different. One can always draw analogies, and analogies are useful, don't get me wrong. But at the same time, I think my concluding remark would be that one has to proceed quite carefully when trying to draw comparisons between, for example, the Crimea situation, the Artsakh situation, because however similar they may sound or come across from the geopolitical, cultural, or other aspects, the reality is that international tribunals will look at each case and apply the facts of that case without really, looking too much at other jurisprudence in as much as it does not represent a crystallized body of international law on a given subject. Because otherwise the tribunals will be very careful, as I said, not to become political judges, or not to be seen as making any political statements or rulings with respect to a given armed conflict or investment dispute. And hence they will be extremely slow to draw analogies from other cases, especially, as I said, if there's certain geopolitical friction here, which makes their role, meaning the arbitrator's role, ever more difficult. So they will have to tread with caution. And I would also urge everyone to make sure to remember this, that analogies are useful, but they're just analogies after all. Thank you very much. This concludes my presentation. I hope I didn't overrun it, sorry.
Thank you very much, Egishe. It was extremely interesting. That's why I didn't want to interrupt any single minute and give the privilege to listen to you, to all our attendees. And meanwhile, we were receiving a number of interesting questions. Some of them were somewhat similar, so I tried to put together some sort of consolidation. So several questions referred to the issue of legality of investment. So if the investment itself is considered illegal under a state's law, how do you overcome that claim, and how you would proceed further with regards to the protection of this so-called illegal? Because, for instance, I'll just quote Ms. Garin-Hovsepian here. She just put the question like this. What if the legality of the investment in the first place is put in question? How would you proceed in this case to begin with? I assume.
Shall I answer?
Yeah, yes, this is a question to Mr. Yanos.
Yes. Well, the issue of unlawful investments and how that plays out in investment treaty arbitration is still a matter of some controversy. There are some cases, and let me take a step back and say what sort of illegality we're talking about can be very important, right? We have seen cases use the question of whether the investment was procured through some form of corruption or that form of illegality come up sometimes in the jurisdictional phase, sometimes in the merits case. Most famously in the jurisdictional phase, we saw some cases against Uzbekistan, Metaltech, and Spantex, both where the issue of illegality was raised at the jurisdictional phase, and it prevented further consideration of the claim. But those were cases involving, essentially some form of bribery and or bid rigging, so that the investment itself never deserved to exist within the laws of Uzbekistan. Other cases involving some form of illegality have addressed that much later in the process. And, to give an example, in the Yukos case, they did deal with, some of the allegedly unlawful conduct of the investors and reduced the value of compensation on that basis, right? So it kind of depends on what the basis for the illegality here is. Now, I assume what the question goes to this notion that when the investment was made, Azerbaijan did not recognize Artsakh and therefore did not, that there's somehow it was unlawful at that time because of the non-recognition of the company, of the country. But I don't know that would be a claim that would be jurisdictional in nature, because first of all, it's not a claim by Artsakh against Azerbaijan. It's a claim of an investor who put property there. Now that property finds itself in Azerbaijan. So it's not that it became an Azeri investment unlawfully. So I would argue that kind of argument shouldn't be jurisdictional in nature. But that would certainly be a live topic. I recognize, but I would say it's probably one that would be bound to the merits and not a jurisdictional issue.
Mm-hmm. Was that also part of discussion during Crimea, Russia, Ukraine dispute?
Well, that's yes and no. No, in the sense that, as I mentioned, because Russia chose to take the empty chair policy, they never raised it, and the tribunals, although they raised a lot of issues on their own, did not raise that one. Russia is starting to raise that kind of an argument now, but I don't think it's quite as good an analogy there, because Russia didn't claim that the Ukraine didn't deserve to run Sevastopol before the annexation. So it wasn't quite as live an issue in that case.
Yeah. However, in our case, it's much acute because Azerbaijan claims the territory and has been very aggressive in its claims and was not recognizing neither the organizational stage, neither the republic itself. So it is quite an issue of contention there. So
yeah, and I think where it could be a much more complex issue is if we're dealing with a license issued by Artsakh government, right, as part of the investment, where the Azeris might argue, well, we didn't recognize that license.
Yeah. Mm-hmm.
But if let's say you have a vineyard. And you've had that vineyard for 50 years. Mm-hmm. That claim doesn't hold nearly as much force, right? Mm-hmm. Mm-hmm. So it kind of depends.
Okay.
Can I just can I just add very quickly? I completely agree with the analysis, but just one thing to bear in mind, because I think the question was because Alex was right to say that there are different types of illegality, and in fact. These days, we see a lot of corruption-related illegality objections raised by the state. But I think in this current context, probably the question was indeed about this whole illegality, as in recognition, non-recognition, Artsakh. And I think let's not forget that one potential tool that can be used to argue for investor to argue against such kind of, or this type of objection by the state would be the fact that in 2010 the ICJ issued a advisory opinion in the case of Kosovo, which obviously does not constitute per se binding principle of international law. But I think it is useful to understand that the fact that Nagorno Karabakh, or the Republic of Artsakh, is independent in as much as it has proclaimed its own independence back in 91. And technically speaking, under international law, at least that's my view, that's not an illegal act. The fact that Armenia hasn't recognized Nagorno Karabakh or any other state for that matter, that's unfortunately, I have to say, also relevant in this context. But let's not forget the Artsakh has declared itself independent. And I think any tribunal would definitely take that factor into account, particularly, as I said, in light of the ICJ advisory opinion of July 2010 in the Kosovo case, which is helpful in this context.
Yeah. Thank you very much, Mr. Dzhazoyan, very important. So the next question I would like probably to, again, and it's addressed to Mr. Yanos. So it sounds like this. Is there a possibility that a tribunal may use the monetary gold doctrine to avoid deciding a claim?
I have to confess, I'm not familiar with the monetary gold doctrine, but what I would say is that when we're dealing with investment treaty disputes, we haven't seen many tribunals decline jurisdiction for prudential reasons in the same way that courts might say, well, this is a political dispute that I don't want to become enmeshed in. As long as you can lay down the jurisdictional predicates, that you have an investment, that investment was impaired, tribunals have shown an uncanny willingness to push past some of these political issues. I mean, I'll give you an example. There's been a ton of noise in all the recent cases against Venezuela because of the question of who runs Venezuela, right? Is it Mr. Guaido or is it Mr. Maduro? Nobody has said, well, I'm not going to keep going because I don't know the answer to that question. It's obviously thorny, but tribunals have just pushed ahead, and whoever's there is there, and whoever isn't there is not there, and they've tried to just stay as neutral as possible, but they haven't held up the proceedings, and we've seen that time and again. So I don't see any kind of abstention becoming.
Just to clarify, so monetary gold principle, I think the person who asked the question meant the principle of not abstaining from adjudicating a case or arbitrating a case if there is some third party's interest at stake who is not involved in this process. So considering in our situation that we have Armenia, Azerbaijan, Nagorno Karabakh, let's consider 3 subjects. So what would be your take on this?
Well, no. I mean, I think the question here is, again, if you have property that is in a region that the Azeri government is currently exercising dominion over. In fact, the Armenian government has conceded that right to dominion. So I don't see how one could argue that Armenia needs to be present for that dispute. So then it's really just a question of was the property taken or not? Do you have a right or not? And is Azerbaijan responsible for that taking? So I don't think that sort of principle could get in the way, or shouldn't at least.
Okay, so the next question would be to Mr. Dzhazoyan. So would the termination be applicable to Armenia-Russian BIT and the Sot mine case? I assume Mr. Dzhazoyan is aware of the Sot mining area that has been partly taken after the war, and currently the investors are in a condition not being able to operate the mine.
Yes. No, yes, it's a, as someone would have put it, it's a $5 billion question. I heard at least some estimates that apparently that the value of that, which I cannot obviously comment on because I don't know, that value of that mine is quite considerable. But look, I think it's a fair question, and I think I don't know much about, of course, the legal structure underpinning it, but to the extent there's a Russian investor there, then I can see that such an investor, leave aside all the political issues and diplomatic issues, such an investor might consider bringing a claim against the government of Armenia on the basis that it had a mine, that mine was lost. Now, it's not the usual case of government taking over. It's more the question of government actually literally losing ground to a neighboring country, but that means that the investments were wiped out. However, I have to say, in my view, there's a very obvious defense amongst other defenses, which the state, i.e. Armenia in this case, could run, which is that, well, look, guys, you knew what you were doing when you were investing. As far as I understand, the whole mining, the whole issue goes back to Soviet days, and there's a boundary-related dispute there, and to the effect that if the starting premise that at least in Soviet times, the disputed territory of the mine was technically, legally speaking, located on the territory of the Azerbaijani Soviet Socialist Republic. Well, I think then, going back to the sort of the whole legitimate expectation, fair and equitable treatment, all these standards of international law, I think it will be I won't say very easy, but certainly an arguable case for the state, for Armenia to run, say, well, you knew what you were doing, hence you're not entitled to any compensation from us. Leave aside everything else. That would be my take. As far as Armenia is concerned, whether the question relates to whether a claim can be brought by the same Russian investor against the government of Azerbaijan, well, I think there again such a claim could exist. That's obviously something they have to think about themselves. But I think again I can see easily a whole roster of array of defenses and objections that Azerbaijan can run here. And again, they mostly go back to Soviet days and figuring out actually how the mine was sliced and diced between the two Soviet republics at the time. And the most important thing, what did the investor know? As I said, in my view, this strikes me as one of those, I wouldn't call them speculative investments, but certainly the type of an investor. It's no coincidence, Adelaide, that we see a Russian investor there, put this way. I'll be much more surprised to see a Swiss or American or German investor. And I think that will already tells you something in that sense.
That's an interesting, a food for thought, actually. Thank you very much. And next question to Mr. Yanos. If there is an Azeri-Swiss treaty, can Swiss national claim an arbitration award, or is just prerogative of the Swiss legal entity?
First of all, there is an Azeri-Swiss treaty. Protected investors are both natural persons and corporations. So a Swiss national would be able to bring a claim against Azerbaijan for some sort of treaty breach if there was one. I should note somebody else asked the question about Article 25 of the Egishe Convention. I assume that was in reference to dual nationals. So, and it is true, if you are an Azeri citizen and let's say a Swiss citizen as a natural person, that would not be possible as a claim under the Egishe Convention, but it would be possible. Although the jurisprudence in relation to dual nationals is developing, let's put it that way. But in theory, a dual national could still bring a claim against Azerbaijan as a Swiss investor under different instruments?
My assumption under this question is that actually the person who asked the question had in mind dual citizenship of an Armenian, let's say an Armenian and American citizen, dual citizen that has made an investment, or maybe Armenia and some other country dual citizen has made an investment in Nagorno Karabakh.
Well, that would be different because
cases.
Yeah, but that would be different because the Article 25 doesn't prohibit dual nationals of that character from bringing a claim against Azerbaijan, right? If you were a U.S. and an Armenian citizen, and you had property in the Nagorno Karabakh region that then became an investment in Azerbaijan, and you were bringing a claim against Azerbaijan, the fact that you were a dual citizen and one of your citizenships was Armenian wouldn't prevent you from bringing a claim if the other one was qualifying, at least with respect to Article 25. There are other issues about dominant nationality that might come up, but leaving those to one side for now, that's Article 25 would not be an impediment for that. Article 25 relates specifically to citizens who have a dual nationality, one of which is the host state, the state that you're bringing the claim against.
Can I just add one thing, because I think it's relevant. I completely agree with Alex's analysis that 25. We shouldn't have a 25 article problem in this context, because it's hard to imagine in theory everything is possible, an ethnically Armenian investor who has an Azeri passport who brings a claim, which will basically be problematic from the 25 Exit Convention article point of view. But I do want to raise the point that, and I have to say I have not done an independent analysis of the 44 bits or however many Azerbaijan has, but I do know for sure that some of those bits, bilateral investment treaties, Azerbaijan has quite cleverly inserted a denial of benefits clause, which says that to the effect, for example, if it's a legal entity bringing a claim, and again, I can't really right now point to any bits, but I know that they exist as such bits. To the extent there's a legal entity, for example, which is controlled economically or whose shareholder or ultimate beneficial owner is a national of a country with which Azerbaijan does not have diplomatic relations, I think no prizes for guessing what that country could be. Then such an investor is not. So it's not an illegality then point. It's just a qualification investor point. Such an investor in that case would ordinarily be denied protection in the first place because he wouldn't qualify as an investor. And I think so. Whatever bits we're talking about, one has to be quite careful to actually look whether such a denial of benefits clause has been inserted, because as I said, the Azeri government, by the way, unfortunately, I have to say, unlike the Armenian government, in the last 30 years, have thought about those issues in advance and have done something about it.
Yeah, interesting. So the next question again, Mr. Dzhazoyan, could the VCLT Articles 61 and 62 be applied by a state when it is the aggressor, annexor of the territory? I'm not quite sure what from which side aggression and from which side annexion.
Yes, well, I guess
annexation.
Yes, well, I guess to the extent we talk about aggressor as in the state itself being at fault, well, then I guess of course a whole host of issues can arise here, including bad faith and abuse of rights and such like. But I have to say I'm trying to be trying to find a pragmatic sort of answer. It's almost like the question is directed whether Azerbaijan can be dealt, for example, in this context, is an aggressor. But of course, here I think it will be quite difficult for the Armenians, for example, or the Karabakh or Artsakh side to argue that, unless, of course, again, we're talking about the borderline incidents with respect to, because let's not forget the hostilities did spill over into Armenian territory, unfortunately. Still a bit quite unclear exactly what happened in most instances. But so in that sense, I think it's a legitimate question in that, of course, the tribunal will take into account the conduct of the state, and the two first kind of two umbrella type of instances where that can sort of I can think of, by way of, for example, denying or somehow the state a remedy which the state would otherwise be entitled to under a given treaty. Those are bad faith and abuse of rights. But I have to say those both those concepts are quite, as Alex put it very nicely about something else, developing. So I wouldn't necessarily bet too much on it. And perhaps one more thing I want to add to that point, because again, I'm not quite sure what the author meant in terms of a specific application of the question. But let's not forget, we talk about Artsakh and potential investors as in private investors, bringing claims, for example, against Azerbaijan. But there's also a further possibility, which is Armenia itself bringing a claim against Azerbaijan. It won't be a pure investment claim, but for example, the first thing which comes to mind would be the 1966 Convention on the Elimination of All Forms of Racial Discrimination. It's a pretty old convention, but I have to say recent events, and I'm sure Alex maybe can add to this, there's quite a few new cases emerging, and two of them involve Russia, and one of them Ukraine, the other one Georgia on the other side. Those are not necessarily brought with the name to, claiming billions of dollars of compensation. But in my view, to the extent I know, that's pretty much the only substantive kind of convention to which both Azerbaijan and Armenia are parties to, and which provides for a jurisdiction of the ICJ, compulsory jurisdiction. So that there's also that, maybe it's not strictly speaking sort of relevant to the question, but I think that we should also keep it in mind that the government of Armenia has a right of recourse against Azerbaijan under certain investment treaties as well. Sorry, international treaties, not investment treaties.
Okay. Thank you, Mr. Dzhazoyan. Next question sounds like more of a statement or conclusive. Can we actually claim that in international investment law, the territory status doesn't matter as it matters in international public law, whether the territory was part of another country or it was not recognized? I think the person who asked the question alludes to the presentation by Mr. Yanos about Crimea. And specifically there, I have the fear about us, the territories are still disputed and there is no status decided. By requesting Azerbaijan to protect the investment or bringing a claim, aren't we, for example, supporting Azerbaijan's claim for sovereignty over the territory? Aren't we sort of harming our own political standing there?
Well, I mean, that was the first or the second issue that I mentioned. A lot of the claims that were brought by Ukrainian nationals against Crimea, this was a major issue as well. They did not want to recognize Russian sovereignty over Sevastopol. They just wanted compensation, and the tribunals did deal with this issue in the Everest case and several others, where they said that you don't have to establish a legal right of sovereignty to make a claim. It just has to be that the country that you're bringing the claim against itself asserts that it has that right. So I think if you were a Swiss citizen bringing a claim against Azerbaijan because you had like I said, like a vineyard that was destroyed or taken by the Azeri government, you don't need to accept Azerbaijan's rights to control the territory, but you do need to accept that Azerbaijan itself claims that it has a right to control that territory, and I don't think that's controversial. They certainly do.
Yeah, not in that sense, but if you consider the case of a dual citizen, Armenia, US citizen, having a windmill over there, a wind power station,
Yes, sure.
let's say, which and considering the ECT, what would that entail? What do you anticipate? Would
right.
that
I mean, I still think the response, I mean, in there you do have to bring the claim as an Armenian because the U.S. is not a party.
Yes.
The argument is still that I have an investment in a territory, and Azerbaijan claims to control that territory. And Azerbaijan has destroyed my investment or taken my investment or exercised dominion over my investment in violation of my rights under the Energy Charter Treaty. I think that's still possible without recognizing any the validity of the agreements between Armenia and Azerbaijan. It's a realpolitik. Recognition, not a natural right recognition.
And thank you very much. And there is a very interesting question that I would like to hear your perspectives on, both maybe Mr. Dzhazoyan and Mr. Yanos. Do you think principles under human rights law may be imported for protection of investors under VCLT's provision not to apply general principles of law? I assume under human rights, probably the right to property. Other?
You want to go first, Alex?
Yeah, well, go ahead.
No, I was just going to say, well, I mean, it's clearly, in my experience at least, tribunals are almost never confined by the language of the treaty, in the sense that to the extent that they feel they're bound or entitled to look elsewhere, be it international customary law or human rights law specifically, they will do so. And certainly that there is a legal tool or mechanism entitle them to do that. And the obvious point, for example, would be Article 31(3)(c) of the Vienna Convention, which talks about any relevant rules of international law applicable in the relations between the parties are to be taken into account, just as one example. But I think the real problem, or not so much problem, but the issue is not so much whether human rights law is applicable. I think the answer to that is yes, in general. It's a question of relevance. Because give an example, we talk about Artsakh, and there were obviously horrific events with civilians losing their lives and casualties and things like that. So you could talk about that, but for example, in the context of the vineyard dispute, right? And then say for example, Swiss national or investor bringing a claim against Azerbaijan for the destruction of a mill or a vineyard or some sort of business in the Nagorno Karabakh territory, and at the same time trying to exploit, in a good sense of that word, certain human rights abuses or issues or allegations or facts, in whichever way you want to put it, which happened at the exact same time in the exact same area, but they're not necessarily directly relevant or go to the heart of the dispute. I think, frankly, there I can well see the tribunal being, while sympathetic to the cause, I don't think they will necessarily take that into account, because they don't really go to the subject matter of this hypothetical dispute what I just described. But of course, at the same time, coming back to my example with the Racial Discrimination Elimination Convention, that's a primary example of how international human rights law can actually provide the very mechanism and the very basis for bringing a substantive claim by the government of Armenia against the government of Azerbaijan, including by way of claiming losses and compensation. So the answer is yes, but again, the real question is relevance rather than application, in my view.
I think that's right. I mean, the only thing I was going to say is, people maybe thinking, well, what about lawsuits in the United States to vindicate their rights and try to piggyback on those principles in that context. It's theoretically possible to construct a lawsuit that might survive various motions to dismiss that it would face. My view is that any kind of litigation of that sort would involve years, if not decades, of motions to dismiss of various kinds, and those and would lead to very unlikely success. If you look at the cases, the recent cases involving Hungary and Germany on property that was stolen during World War II. Those were, the Supreme Court was very unsympathetic. I don't see those kinds of lawsuits bearing any fruit. They might be cathartic from a personal standpoint, but unlikely to lead to any kind of awards of actual money.
Thank you very much again, Mr. Dzhazoyan, Mr. Yanos. This was a very interesting discussion. Thank you for your presentation, for your very valuable time. And we appreciate your participation in this discussion and presenting very important questions for our scholars, students to consider. And I'm also very thankful to our coordinator, LLM program, ADR Clinic, Aram Aghababyan. You're hiding behind the icon there. I know you are there. So thank you so much. And I look forward to organizing this kind of a webinar again. It has been quite populated, I'd say. We started with around 50 participants. So thank you very much for enlightening us with this information and with this knowledge, and looking forward to seeing you again.
Thank you.
Thank you. This was a lot of fun.